There's a concept that goes hand in hand to some degree with adverse possession, but it has much broader application. It's the concept of prior appropriation and beneficial use. And those concepts are the concepts that underlie the way the American West was settled to this day in all the 11 Western states. Western water law, which is governed by state law, is based on prior appropriation and beneficial use. What it means basically is first come, first serve, use it or lose it. Possession is 9/10 of the law. Those basic principles apply to water, they apply to land, they apply to other resources, they apply to forage, to timber, to minerals, to oil and gas. And again, I've referred to this. This is basic stuff. Again, go to Wikipedia. I mentioned that this ties to some extent to adverse possession. If you go to Wikipedia and look up adverse possession, it talks, among other things, about squatters' rights. And it talks about homesteading and the basic principles of homesteading. And it says, among other things, and I'm going to read part of this quote, the principles of homesteading and squatters' rights embody the most basic concept of property and ownership, which can be summarized by the adage, possession is 9/10 of the law. Meaning the person who uses the property effectively owns it. Likewise, the adage, use it or lose it, applies. The principles of homesteading and squatters' rights predate formal property laws. To a large degree, modern property law formalizes and expands these simple ideas. So, those are the basic fundamental principles that form the foundation, not just for state law, but for federal law. Those are the principles that served as the foundation for all the homesteading acts passed by Congress. And the thing that you need to understand, a lot of people seem to have some basic understanding of what a homestead is, that if you staked claims to 160 acres or twice that much, 320 acres, or 640 acres in some places in the West for stock raising homesteads, that you would stake the claim. It had to be on property that wasn't being possessed and used by someone else. No one else had a competing claim to that property. And you staked your claim and you possessed it and you put it to beneficial use. You scratched the surface, you tilled it, you cultivated it, you built a cabin, you did whatever it was you did. In some cases, you just grazed it. That's all you had to do under the Stock Raising Homestead Act. Put it to beneficial use by grazing it. You could acquire outright title. You could acquire that property through beneficial use because you possessed it, you put it to beneficial use, you were the first appropriator, prior appropriator. First come, first serve, use it or lose it. Possession is 9/10 of the law. Now here's the concept that really throws people off, even though that applies to the acquisition of a homestead, which is how most ranches in the West were developed, how they were acquired at the outset, land that at the time belonged to the federal government. But then there's this concept of these grazing allotments. They can be much larger than just a 640 acre, which is considered a one section homestead. That can include many sections or even townships of property. But under the Stock Raising Homestead Act, you could also acquire, and other acts, other congressional acts, you could also acquire a private property interest in the split forage estate. The land still belonged to the federal government, but you could acquire by prior appropriation and beneficial use an actual property interest in the split forage estate. You acquired a private property interest in the grass, in the forage that your livestock utilized and put to beneficial use, and the water that they utilized. You could acquire interests not in the land itself, not in all the other resources, not in the subsurface estate, not necessarily in the timber, unless you put the timber to beneficial use. But in terms of the forage, and the same applied to each and every other of the split estates on the federal domain, whether it was the timber estate, the subsurface mineral estate, the forage estate, the water estate, which was governed by state law. Those are all examples of how property rights in the West are acquired by prior appropriation and beneficial use. They're the basic principles that underlie the settlement of the West that seems so confusing to so many people, but they apply today, they applied 100 years ago, and that's part of what we're applying, and it's part of this conflict between urban and rural America and the understandings that people have based on their backgrounds. We realize that that's not the way things work everywhere else. But out west, that's the way it worked, that's the way the West was settled, and those are still the same principles that we operate based on today. So that's a nutshell crash course basically in prior appropriation and beneficial use. Now I'm going to come back and I'm going to talk about some basic legal tools for federal range allotment owners that applies a lot of these same principles of prior appropriation and beneficial use.